So and then the other case that they cite, Torrance versus King County. Torrance was a case where the petitioner came to court too late. The county had made a zoning decision. The petitioner had not appealed it in time. And then later on, the county made another decision, and the petitioner tried to raise the issue at that time. The court said, no, you're too late. You had the chance to file your appeal earlier on, and you should have appealed then. So neither the Grandmaster U case, where they moved too early, or the Torrance case, where they came too late, neither of those have anything to do with the facts of this case. We're here at the right time. We filed the petition shortly after the lease was entered into. We raised SEPA, we linked it, in the words of the cases, we linked the SEPA claim with our challenge to the underlying action. We've done things exactly right. The other issue that they've raised is standing, and I really think this is frankly close to a frivolous issue on their part. We alleged in the petition that members of the group, of the Concerned Citizens group, live next to this proposed facility, and they'll be adversely impacted by the air pollution and the water pollution and the truck traffic and everything else, noise, lights. That's all you have to do for to allege standing. And if that wasn't enough, kind of to add several layers of icing on top of that, we then, when they raised the issue, we filed 4 or 5 declarations from citizens to further elaborate on those direct impacts that will be suffered by members of the group. I don't really know what more I can say about that, I guess, other than the one case they rely on that for that is very off point. That's a case arose in Snohomish County where a developer, or not a developer, a planner, who's a land use planner, Trepanier, sought to challenge a zoning decision made by the city of Everett. And he was claiming that the city zoning decision was going to cause more growth to occur in the city, or actually less growth to occur in the city. It was going to push growth out into the county where he did business, and that somehow this zoning change in the city was going to impact him out in the county somehow. It was convoluted. And the court had no problem saying, you know, this kind of convoluted argument as to how you're directly impacted by this project. There's just no evidence in the record to suggest there's any legitimacy to this claim at all. That's the case they're relying on. The cases are legion, that the folks who live close to a project and are going to be directly impacted by the traffic or the noise or the air pollution from the project have standing to challenge. And you know, that's the Anderson case, the Levitt case, the Suquamish tribe case. These are all cases that stand for that same proposition. So I don't think there's any basis for really hesitating very long at all on the standing issue. So with those 2 issues dispatched, I think the appropriate thing for the court to do is deny their motion to dismiss and to issue the writ. Thank you.
Thank you. Go ahead.
Good afternoon, Your Honor. The case before you is very simple, and that is the court does not have jurisdiction to issue a writ in this case. And the appropriate remedy is to dismiss concerned citizens' action. First, I'd like to briefly say what is at issue and what is not at issue here. There are 3 claims or causes of action before you from petitioner's petition. First, the statutory writ. It is uncontested that the statutory writ does not apply here. There was no quasi-judicial action taken by the port, and the statutory writ simply is an inappropriate remedy here. The other 2 issues, declaratory judgment. Declaratory judgments are not available when there are other remedies. SEPA offers the other remedy that concerned citizens needs to follow here. The constitutional writ is an extraordinary remedy, and it is legally unavailable where a right to appeal exists, and the failure to appeal under that right is not excused. All of their claims can be alleged under SEPA and should have been alleged under SEPA. Now, Mr. Lashever in a second is going to explain further why the writ is inappropriate and why the claims needed to proceed under SEPA, but I'd like to address the standing issue for you. The SEPA standing that the petitioner alleges is threatened. There's no existing harm, and I think that would be unchallenged. There isn't an existing power facility, which is actually what is being built here, not a massive incinerator. And we're not talking about the plant or the facility permits. We're talking about the lease option, the ground lease to provide a place where this may be located, where according to the very terms of the contract that petitioners are complaining about, this lease option, not a lease, says that SEPA must be complied with before a contract to lease will exist. So where that injury is threatened, where it doesn't exist, the cases are very clear that what's threatened must be immediate, concrete, and specific. It can't be conjectural or hypothetical. And here we have nothing but a giant if. If the project permits are issued by Mason County and ORCA, the Clean Air Agency, and the SEPA review conducted by Mason County goes through, then petitioners have standing to challenge those things. Here, you have a lease option which doesn't do anything in terms of putting this project forth. It has, if SEPA is complied with, and the SEPA review is being conducted by another agency, and the permits are obtained from up to at least 9 other agencies that aren't the port, then we're talking about an injury that may be immediate, may be concrete, may be specific. But here, that hasn't happened yet. So, in their complaint, they haven't alleged facts in the complaint, which is what we're here on. We're here on the complaint, not these additional pleadings. In their complaint, they have one sentence as to what their standing is. Concerned citizens of Mason County members include residents of Mason County who live on property next to the proposed site, as well as residents who live throughout the county but who will be exposed to the adverse impacts of the plant's operation. One of the adverse impacts is the legal conclusion. No one's concluded one way or another yet, because that SEPA review is ongoing, what the impacts of the plant are or are not in terms of adversity. 2, these other things that Mr. Berkland just talked about in terms of diesel fumes and other things, other harms, they're not alleged in the complaint. Even if we take what the plaintiff's declarations are as true and we consider them here, again, we still come back to the same problem. You know, yes, they may live next to somewhere where if SEPA review is completed by Mason County, and Mason County and at least 8 other agencies issue permits and approvals for this project, then there may be a SEPA claim. But now, and SEPA standing for the petitioner. But now, because we're only on this lease option, right, there's no immediate threat. There's nothing concrete. There's nothing specific. And we don't agree that plaintiff's declarations are properly before the court. Much of what are in the declarations, and I won't belabor this point, are inadmissible under, for lack of personal knowledge, their opinion testimony by lay witnesses that isn't properly qualified. It's purports to be expert testimony when there's no basis for the expertise, and much of it is hearsay. And one of the 4 we received 1 page of, so the Penoria Declaration, so we haven't had a chance to review that. But in any case, even if we take what these folks that are members of the petition are saying, as true, we're still here, we're not here on the project, we're here on this lease option, right? It's something that's remote. It's not immediate, it's not concrete. The impacts of which they're complaining don't arise from the lease option, they arise from the permits and the project later on down the road. If you have further questions on the standing, I'd be happy to answer them. Give Mr. Lasher the floor to talk about the writs.
May I approach, Your Honor?
You may.
May it please the court, I'm Eric Lashover here on behalf of Adage and Adage Mason. And as Mr. Schechter indicated, I'm going to just focus on the part of the motion to dismiss the specific claims before you. And as noted, one of them everybody agrees isn't properly before the court. That's the statutory writ. And so I'm going to focus a little bit more on the constitutional writ and the declaratory judgment action. And I want to begin with what the appeals section actually literally says, in contrast to what the plaintiff's counsel argues it says. And I direct the court to the highlighted provision of 4321C 075, in particular where it says, appeals under this chapter shall be the governmental action together with its accompanying environmental determinations. And the governmental action in this case is the option to lease. And so what this literally says is appeals under this chapter, which is SEPA, is of the underlying governmental action. Now you've heard opposing counsel say there's no direct way to appeal a lease option. But what this explicitly says is that the underlying action, the lease option, can be brought, and it must be brought together with the claim of SEPA. And so there is clearly an adequate remedy of law that allows them to challenge the lease option and to bring the SEPA claim. Now, if the statute wasn't sufficiently clear on that point, we cite in our brief the legislative history from when the legislature added this appeal provision. SEPA, when it was adopted in 1973, didn't have an appeal provision, and so what happened was motion practice and other devices were used to bring them, including under other statutes and writs. And there was a commission that was brought together to look at the 10 years of experience under SEPA, and that commission recommended that an appeal provision be added. And our brief excerpts from the report of that commission, which explicitly says the reason why we want to add an appeal provision is so we can do